James is Gary Koger, and next to Gary is Preston Bristow. And our recording secretary is Kathy Hasbrook, who's got hopefully all your signatures on the sign-in sheet. We have a small agenda to get to before we start the hearing. And has everybody signed in? Thank you. Item number 1 on the agenda, we have the minutes from our October 11th, 2023 meeting. Take a motion to accept.
I move that we accept them.
Second.
Moved by Harry, second by Gary. All in favor of accepting the minutes as?
Aye.
Aye.
Any discussion, any additions? Let me finish. Corrections of those minutes that anybody noticed? None? Thank you. All right. The next item on the agenda is a line item called citizen comments. Anybody can say anything they'd like, not about the hearing. We will start the hearing after the citizens' comments. If anybody on Zoom would like to say something, this is your time, not about the hearing. Silence is deafening. Thank you. We are going to now reconvene the conditional use hearing number 594, Julian Materials, Oil Stone Quarries at 3643 Vermont Route 103 North and 137 Chandler Road. I think we have to, anybody who's planning to give testimony has to be sworn in?
Yep.
And if not, it doesn't count if they were already sworn in before, correct?
I'm going to want to do it, I think, every time out.
Okay.
Yeah.
So those that want to give testimony,
If you could stand,
And-
raise your
and-
right hand, please.
Attorney Carroll will issue the oath.
Do you solemnly swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth, so help you God? Thank you.
All right, now we started the hearing. Has any of the board members have any conflict of interest with this hearing?
No.
Hearing none. Any of the board members have any ex parte communication to report?
No.
Thank you. We have a number of exhibits that we need to be entered into. And we can start here, I assume. And there's a number of exhibits that we need to be entered into. Am I good here?
I'm hearing Bob all over again.
We can start here, I assume. There's a tape delay.
Apparently.
Is that me, Amy, or?
I don't know what that was. Is that you talking?
There was somebody on Zoom with their mic on.
Oh, I see. It comes through, so we need to mute those people, right?
Yeah, please.
Is that what happens?
Thank you.
I think everyone is muted.
Okay, thank you. Can I just go down this list?
I guess that would be the way to do it. I mean, there's certainly been a flurry of exhibits that have come in. I think it's important for the purposes of the record, particularly since this would be an on-the-record appeal, that we have track or keep track of the documents that parties are looking to actually have admitted, marked and admitted as part of the record. If I kind of went back through everything, the batches, I think that came in were the response to the subpoena that came in, and I think there's a document that, Preston, if I'm right, is actually marked as an exhibit on here as to the response to the subpoena, but I don't know that all the individual exhibits or the individual documents were actually marked or submitted in any specific format. Would I be right in thinking that anything that a party wants to have admitted as an exhibit has been either marked by you, Jim, on behalf of your clients, And the same with you, Mark, and you, Steve. I mean, I guess what I'm wondering is that the total information that got submitted as part of the subpoena response, is anybody offering all of that or any of that other than what you have on your list as an exhibit in this matter?
Yeah, this is Jim Dumont speaking. Thank you for asking, and I want to thank Preston for doing an amazing job today to get everything that we've all sent by email onto the town's website. Thank you so much.
You're welcome, and I will say that the response that Attorney Mark Hall sent, that entire response is on the town website as item II.
Okay, so not only the written response, but all the documents that were also
Right.
sent are now
Right.
on the town's website and
Yes.
marked as a single exhibit, Preston?
As a single exhibit.
Okay.
And then item JJ was a response to question 2 that came in separately. But
Okay.
all of the materials that Attorney Hall sent are on the town website and have been delivered to the DRB members. Some of it was on Friday and some is on their table today.
If I may, Jim, we are not offering those as exhibit, we're offering them as their request for the production.
Response.
So, yes, because don't see a lot of the documents as being relevant to any criteria, so to the extent that Jim wants to use particular ones, I think we should limit the record to those that are offered by a party.
Well, for clarity's sake, this is Jim Dumont speaking. For clarity's sake, I am offering all of them. I think we don't have time to go through them one by one and ask the board to make rulings. They've all been produced by Mr. Hall, so I'm asking that all of them be admitted into the record.
Yeah, and I'll put an objection on the record for that because they have to show relevance of a document for it to be admissible. So, but I'm not going to make you go through it otherwise, so we'll just preserve that one for a later day.
All right, so you're satisfied to put an objection basically on the record?
Yes.
All right.
And Jim, I want to add one more thing. We have an exhibit that's a flash drive that Leslie and Scott have assembled, and we're going to offer the flash drive as an exhibit.
Excuse me, Jim, could you pull the microphone closer?
I'm sorry.
Thank you.
In addition to the documents, we are also offering a flash drive with the video recordings on them that will be played this evening. And so the record is clear, we do not suggest that the video recordings are accurate simulations or accurate copies of the loudness of what's heard, because most of them were taken on an iPhone. So we're not offering to prove how loud something was or how loud something wasn't. But the recordings have other relevance to you, such as how frequently the hammer was hitting. We can agree or disagree about whether the loudness is correct, but how frequency it's hitting, I think is very reliable, and we're offering them for those purposes, the context and the frequency of the hammer hitting, not how loud they are.
I don't think we would object to that because I think
That
it
would
is
be
what it is.
Exhibit MM. We have a list of
Oh, you do?
exhibits.
Okay.
That would be Exhibit MM.
Well,
On list.
what Jim Dumont is talking about, Attorney Dumont, is actually would be Exhibit 23 under, because we segregated them. Those are documents from interested persons.
That's Exhibit 23. So what Exhibit?
There is an Exhibit MM on the list, but Attorney Hall has said that he doesn't think it's necessary that we submit that.
Okay, so we're going to cross off MM.
It's, yeah, I think you can. It's 2 video clips of the stormwater system at Chandler Road.
All right. We're still,
I just want to check with you, Mark, is that?
Yeah, that's fine. That was just a
We're not offering what has been marked as Exhibit MM, which is a video of the Chandler Road Quarry stormwater system.
We are not. That was a response to the subpoena as well.
So Exhibit MM is a component of what was responded to in the subpoena.
Yes.
As I understand it, Mr. Dumont is interested in having all of the documents responsive to that put into evidence, marked, admitted, and used. And as I'm understanding it, you have a running objection
Yes.
to that. But understandably, and from the standpoint of efficiency, if the DRB decides to admit all of the documents that are responsive to that, you'll just want to note for the record your objection so you can deal with it later on
Yes.
appeal if necessary. Is that right?
Yes. And I would say the is actually a video that's in the response to the subpoena. There was a difficult format for the video that people couldn't open, so I had my IT people put it in a different format so you could view it easier.
All right.
Excuse me, Mark, if you're going to respond, you need to move the microphone closer. Not everybody can hear.
Just to say the is part of the subpoena response as well. It's just an easier process or better process format for the video so people could watch it. Some people had indicated to me that they couldn't open the video that came along with the subpoena, so we fixed it for you.
Okay. So would it be accurate to say that other than the documents you produced in response to the subpoena, that the other exhibits that were passed around today, that Jim intends to use here today, the other exhibits that were submitted and the other documents, you're not having an objection to those?
No, I see P1 through P8, and I have no objection to those.
Okay. All right.
You can vote on these.
Yes, I think so.
Okay.
Is there anything else that any interested party or any attorney would want to add to that conversation? All of these things, by the way, are online at this point in time and can be viewed on the website. When they get put up there, just as a matter of housekeeping, they get marked so we can figure out what they are, keep track of them. And then at some point in the process, which the DRB is about to do right now, they'll make a decision about whether to admit those documents into evidence so that they can consider it when they go into deliberations and make a decision. Does that make sense to everybody?
Yes.
All right. We have a list of, we have Exhibit II, which is a response to the DRB order.
Excuse me, Bob, I have a question about II.
Okay.
Looking at subpoena response number 6, page 2, this looks to me like it was photographed at the Chandler Road site. Is that correct?
I couldn't tell you. I'm sorry.
Can anybody from Allstone tell me whether that assumption is correct?
I'm assuming it is.
Okay.
Because that's where those pictures came from, was from the Chandler Road site, yes.
Okay. Thank you.
Good.
Yep.
Thank you. I'll take a motion to admit Exhibit II, a response to the DRB order.
So moved.
Moved by Harry.
Second.
Second by Gary. Any discussion regarding Exhibit II? Hearing none, all in favor of admitting Exhibit II?
Aye.
II is admitted. We have Exhibit JJ, response to question 2 of the DRB order, which is a letter and responses going back to May 2009. That would be Exhibit JJ.
So moved.
Moved by Harry.
Second.
Second by Gary. Any discussion regarding Exhibit JJ? All in favor of admitting Exhibit JJ, the response to question 2 of DRB?
Aye.
Thank you. We have Exhibit KK, the RSG noise memorandum of May 10th, 2004, from Kevin Hathaway and Kenneth Kalasicki. I'd like to admit the RSG.
We accepted as exhibit KK.
RSG Noise Memorandum of May 10, 2004. Any discussion regarding that exhibit? All in favor?
Aye.
Thank you. Moved by Harry, second by Gary. I'm sorry, I missed that. And we have Exhibit LL, an RSG Noise Memorandum of September 13, 2004.
I move we accept it.
Moved by Harry. Second. By Gary. Any comments, questions regarding Exhibit LL? All in favor?
Aye.
So moved. All right, moving on. Yep, here it is. We have Exhibit 21, which is an email from Mark Hall dated 4:03 p.m. on October 16, 2023.
Can I just interject one thing before we move on? Exhibit MM is in fact a component of Exhibit II. Is that right?
Well, that's what Mr. Hall indicated, is that he had sent it
All right.
as part of the response.
All right.
As I said, it's 2 video clips.
We don't need to, I mean, we don't need to. It's just, I think, as a matter of record-keeping reference, Exhibit MM is subsumed within Exhibit II, as I understand it, Mark.
Yes.
Okay, thanks. And your objection, again, just for the record purposes, is based on relevance in connection with the items that you...
Yeah, I just don't want to blanketly put everything into the record.
All right. Well, as things come up, you might want to, as things come up and Jim's actually using documents, you might want to explain specifically in connection with those documents.
Yes,
Do you
I
have
think
anything
with regard to
further
any
by way of-
document that's shown to be germane to the cross-examination of a witness, for example, is going to be admissible, and we can deal with them on that basis as they come up.
Okay.
We have a few more exhibits to admit. We have a email chain from Mark Hall dated 4:03 p.m. on October 16th, 2023.
I move we accept it.
Moved by Harry.
Second.
Second by Gary. Any discussion regarding Exhibit 21, an email from Mark Hall dated 4:03 on October 16, 2023? All in favor?
Aye.
Thank you. We have Exhibit 22, a Scott Kildas markup of TCE plans for South Quarry. Moved by Harry.
Second.
Second by Gary. Any discussion regarding the Scott Kildas markup of TCE plans for South Quarry?
If I may, I would just like to wait till he testifies relative to the exhibit before I waive any objections we might have to it. I just want to see the relevance of it again.
You okay with that?
Yeah, we're on
Exhibit 22.
22, yeah. Well, it's been marked as Exhibit 22. Jim's going to be using it. So you're going to put on the record your objection, again, not sure, until such time as the testimony occurs?
Yeah, and once he testifies to it, then we can take it up there, and I most likely will just say, fine. I just want to have it explained first.
Okay. Jim Dumont, do you have any response to that in terms of waiting on the admission of Exhibit 22?
It's entirely discretionary with the board.
All
If you
right.
want to wait, you can wait.
Yeah.
I mean, we can admit it and then go back to it.
Well, once you've admitted it, you've kind of admitted it.
Well,
Yeah. So,
it's still become part of the record.
Yeah, Exhibit 22 is, goes with the testimony you're going to hear from Mr. Kilgus of how he calculates the amount of rock that's going to be removed from the South Quarry. It's very relevant.
As soon as he testifies to that, I'm going to allow it to be admitted and not object to it. I think that's probably best to wait till he testifies to it so we can have a foundation for its admission.
I'm inclined to
Table it.
table it.
Okay, so Exhibit 22, we are not voting on at the moment.
Okay.
The video from Leclerc, Kilgus Thorson, and RSC, how are we handling that?
See,
That
move to admit.
moved by Harry,
Second move.
by Gary. Any discussion regarding the video from Leclerc, Kilgus Thorson, and RSC? Hearing none, all in favor?
Aye.
Thank you. The video is admitted. We have 3 more exhibits, and they are the Unified Development Bylaws of the Town of Chester, Vermont. First one dated October, that would be Exhibit P6, is the Town of Chester Unified Development Bylaws from the 8th of October, 2014.
I move we accept it.
Moved by Harry, second by Gary. Any discussion regarding the Unified Development Bylaws, Town of Chester, Vermont, dated October 26th, this is backwards, 2014. Okay. All in favor? Any discussion regarding the bylaws? Sorry. All in favor?
Aye.
The Town of Chester Unified Development Bylaws of October 2014 accepted. Now we have Exhibit P7, Town of Chester Unified Development Bylaws from April 5th, 2017.
I move we accept them.
Moved by Harry,
Second.
second by Gary. Any discussion regarding the Town of Chester Unified Development Bylaws of April 5th, 2017? Hearing none. All in favor?
Aye.
Those are 2017. We have Exhibit P8, the Town of Chester Unified Development Bylaws from the 5th of July, 2023.
I move we accept them.
Moved by Harry, second by Gary. Any discussion regarding the Town of Chester Unified Development Bylaws from July 5th, 2023? Hearing none, all in favor?
Aye.
All righty.
Bob,
Yes, yes.
I have a document that I'd like to enter as an exhibit.
Sure.
Just for clarification, the P8, I think the date on it is 22, not 23. It's the current bylaws.
Well, the bylaws just keep getting changed, so the very current ones are July, if you want
Okay.
the most current.
All right. The paper copy in front of you is October 2022. But certainly, we can substitute, well, I suppose it's up, whether Mr. Hall might have an objection to ones that were adopted after the application was filed. I don't have a position on that.
14, 17, 20.
I'd have to review the ordinance in full to determine whether there's been any change to the ordinance relative to this project. If there hasn't, I wouldn't have any objection, but I would suggest that we go with the bylaw that was in place when the application was filed, because I think the court has been very strict about that, and that subsequent changes are irrelevant.
I think I would agree with that, which I think means maybe we have to have another exhibit.
I think we can find it and get it in.
So the paper copy I have is 2022.
Right.
Yeah. That you all have is 2022.
Yeah, so we should, we should basically correct the exhibit list to reference, what's the date that you have?
October 26th, 2022.
Okay.
Bob, may I?
I'm sorry, Phil. Yes, go ahead.
If we look at response to subpoena response 3 and 10 on page 5, one of the pieces of equipment is this Komatsu hydraulic excavator. And on page 7, there's a specification sheet. If we flip the page to 8, there's a photograph of a Komatsu wheel loader, but there's no specifications for that piece of equipment. So I would like to add as an exhibit a specification sheet for that WA 200-8 that includes the noise specification for that piece of equipment. Take one, pass it down.
These are all the same?
Yep.
Yeah, I think,
Need to see this.
Right.
I think, Jim, just overall, the board conducting its own research
Yeah.
is problematic, but if it matches, I don't care. I do think that's problematic for any appeal that takes place.
Well, I think I can take notice of documents that are publicly available on the internet.
Yeah, for the record, this is Jim Dumont. I move to admit that these, what Mr. Perla just mentioned.
I don't agree with that statement that I think there's ample case law indicating that a deliberating board cannot conduct its own research.
This is Jim Dumont.
But in any case, if it matches and I have an opportunity to do so, I'm happy to let it in.
Just for the record, on behalf of my clients, it is acceptable for a board to do its own research so long as the research is put in the record and all the parties have access to it, which is what we're doing.
I would disagree with that.
Yeah, and that's all fair, so, I mean, get that put on the record. But I do think before the board actually votes on this particular item, that, Mark, you need to see it, have a look at it. And
Yeah, if it's the tempest in the teapot, it's the tempest in the teapot. I'm not going to object to it, but I just need to have a chance to look at it.
Yeah, okay. So would there be any objection to tabling this until the attorneys have had a chance to actually look at this, or the interested parties?
No?
Thank you.
But we can mark it. Preston, we mark that as exhibit.
NN, Nancy.
Thank you.
And we'll hold off on accepting that. Or admitting that, correct?
Yeah.
Okay.
Go ahead and give a copy.
Have you got that sheet?
All right.
No, I was looking, did you get the specs that Bill Perla? Okay, just kind of wanted to write it down. Yeah.
We've got everything we need.
Okay. Yeah, I know, it's pretty.
All right.
Thank you. Thanks. If anybody else would like to see this, I could get it to you now. It's gonna be on the website.
Thank you, Jim. All right. Anybody have any comments at the moment? Any questions from anybody? Mr. Attorney Dumont, Attorney Ancuda, Attorney Hall?
Nothing.
Anybody like to present anything?
Yes, we're ready to proceed with our expert witness.
Go right ahead.
This is Mr. Herb Singleton, and Herb, do you want to take that microphone and see if it works, so we can do a question and answer? Or I can give you this one.
Is this working?
Yeah.
Mr. Singleton, please state your name, your occupation, and tell us about cross-spectrum acoustics.
Sure. My name is Herbert Singleton Jr. I am the president and co-founder of Cross Spectrum Acoustics, headquartered in Western Massachusetts. And Cross Spectrum Acoustics is an acoustical consulting firm. We've worked in a number of areas, including transportation noise and vibration analysis, community noise and vibration analysis, construction noise, architectural acoustics, and various other areas.
Describe your education, your experience, and your professional licensure.
Sure. I have a degree in mechanical engineering from the Massachusetts Institute of Technology, where I focused on acoustics and spent 2 years there working at the Acoustics and Vibration Laboratory. I've been working in acoustics and noise control since 1995, so that's about 28 years of experience. I am a licensed professional engineer in 4 states, including Massachusetts.
Excuse me, could you speak a little louder? I mean, the mic is picking you up.
Here, maybe this one's better. Why don't we switch? Add acoustics.
If only you knew somebody. I have a degree in mechanical engineering from the Massachusetts Institute of Technology. I spent 2 years working in the Acoustics and Vibration Laboratory during my undergrad. I am a licensed professional engineer in 4 states, including Massachusetts, and I am board certified in acoustics and noise and vibration control by the Institute of Noise Control Engineering.
Have you played a leadership role in any organization of acoustical experts?
Yeah, so I have been on the board of directors for the Institute of Noise Control Engineering. I've been an officer with the Boston chapter of the Acoustical Society of America, and I am currently on the certification board for the Institute of Noise Control Engineering.
Can you describe what the Institute of Noise Control Engineering is?
Yeah, it is an organization of noise control professionals with a mission of educating the public and promulgating standards and experience and education for noise control professionals.
Could you provide examples of the kind of acoustic engineering work that you have done?
So at this point, I've worked on, it's got to be thousands of projects. I've worked on transportation noise and vibration, usually capital projects for subway and transit systems. I've worked on construction projects all over the country. I've worked on energy projects throughout the Northeast, including in Vermont. And I've worked just a number of different projects, both for project proponents and on the community side for various large projects that can affect a community.
Have you testified as an expert witness before administrative agencies or courts?
I've testified as an expert witness in courts or legal hearings in 6 states, including Vermont, and I've given expert commentary at public meetings throughout the Northeast and in various states around the country.
Please explain generally how the noise impacts of a project on a community can be predicted.
And so, started from the beginning, so noise and vibration engineers, acoustical professionals, we use what we call noise models. Those are scientific equations that, based on measured data and based on site-specific parameters, based on community layouts, based on how equipment can operate, we can use those to use that combination of information and equations to come up with predictions of noise levels at different locations away from various noise sources. So again, so we're using a combination of mathematical equations and real measured data to come up with these future prediction of noise based on how that source is operating, based on the changes in elevation of a site, and based on how that site is operating and where people are located in relative to the noise source. We come up with noise levels in a number of different formats. What is most common are A-weighted decibel levels, where A weighting refers to adjustments that are made to sound levels to simulate how human hearing works. The human ear does not hear all sounds equally. We hear mid-range sounds, that's the sounds of our voices, we hear those the best. Very high frequency, treble sounds like whistles, we don't hear those, our ears don't hear those sounds as well. In very low frequency sounds like a bass or a drum, we don't hear those sounds as well. So A-weighting is a way of adjusting any sound that a microphone can pick up to simulate how a human ear would actually perceive it. And then we have these sound levels that we can measure, that we can predict, and they can be in terms of average sound levels, which we refer to as the equivalent sound level, LEQ, that's the 3 letters L with a subscript of EQ. We can look at the maximum sound level of a sound. So if you think about something like a car passing you by on the highway, as it's far away, it's very quiet. As it gets closer to you, it gets louder and louder. When it reaches the closest point of it to you, it gets very loud, and then as it drives away from you, it gets quieter. That top part, that peak of that sound where the car is closest to you, that would be the maximum sound level, or LMAX, of that car passed by. And there are other parameters we can use to characterize noise, but I would say the two most common, and probably what we're going to discuss today, would be the average noise level, LEQ, and the maximum noise level, LMAX.
Please tell us the documents you have reviewed in this matter.
So the documents that I reviewed were an affidavit from Leslie Thorson, and then 2 reports from RSG, one dated June of this year and the other dated October of this year.
Did a member of your firm attempt to measure the noise generated by Allstone's hydraulic hammer at the South Quarry?
Yes, so one of my associates, a gentleman named Paul Campbell, we had tried to make arrangements to conduct our own sound measurements of noise from the Allstone hammer. We had hoped to be able to measure noise levels at a fairly close distance to where the hammer was operating, so that we would know we would get nice clean data from that hammer. We were told that we were not permitted to do that due to safety reasons.
I will now get to refer the board to Exhibit 21, which is the email from Attorney Hall we received the evening before the visit, where we were told that Mr. Singleton's associate would have to stay at the property line. Mr. Singleton, do you and your firm have experience working in dangerous quarries, construction sites, and so on?
We do.
And how do you handle that?
Typically, we are provided with safety training to make sure we understand the best practices with regard to safety at those sites, and then we're usually required to wear some sort of personal protective equipment, or PPE. And so my staff, we all have hard hats, hard-toed boots, safety glasses, hearing protection, and safety vests, safety pants, and other equipment for those sites.
So in your judgment, could your associate have safely witnessed the operation of the hydraulic hammer?
Yes, so Paul in particular, he has been working or will be working in a number of fairly hazardous areas, and he has received safety training at least 3 times to work in these areas. And at this point, we're pretty experienced with being able to work in hazardous conditions.
Why is it important to witness the operation of the hammer?
So with regard to really any noise source, but specifically with hammers, where, for something like a pneumatic or for a hydraulic hammer, where the noise is being generated by the, not by the actual equipment, not the motor or the pumps and the equipment. It's the actual act of the hammer striking the rock to be broken. It's that actual impact between the hammer point and the rock that causes the noise. And that noise level can change based on the force being used of the hammer, depending on what kind of rock is being broken, where that rock is in terms of is it being supported or something, or on the ground. And it's again, the noise models that we use to predict future noise, they're based on measured data from from the equipment that we measure. And we need to be able to know that what we measure is representative of how that equipment is going to be used in the future. And in particular, in trying to get sort of what we call reference noise levels, where we're measuring noise from this equipment, we want to be able to determine or be able to see for ourselves how that equipment is being used so that we can have some way of being able to know, is this representative of the way the equipment will be used in the future?
Can I interrupt you for the question? Our bylaws on noise set a standard at the property line, not at an arbitrary distance from the source. So did you measure the sound at the property line?
So we did measure, for what we did last week, we did measure at the property line, but what we were trying to do, it was a couple of things, but one of the things we wanted to do was have a clean measurement of the noise from the hammer so that we could use that in our own noise models to predict future noise to see if what we were reading for the RSU reports was, if what we got would agree with what they had. The other issue is, and of course I just forgot my train of thought.
The question was about the property line. Did you measure at the property line?
Well, the other issue is, to be able to predict noise levels at the property line, you need to know the distance between the source and where you're measuring at. So in this case, when we were measuring at the property line, we were out of, the hammer was out of the line of sight, so we couldn't even tell how far away it is. So that makes it difficult to be able to use that data to predict future levels.
This isn't an application of the inverse square law. We're looking for an empirical measurement of noise at the property line. Regardless of how far you are from the source, your decibel meter at the property line would tell you whether it's above 70 or not,
May I ask a question, please?
if it's on the same topic. Yeah.
Yes, it is. Am I understanding you correctly that by being deprived of the control of your initial settings, that you were basically denied the ability to have accurate readings at the property lines?
No, so our intent was not to determine compliance with the property line setting right then and there. Our intent was to be able to use the data to come up with our own predictions for future conditions.
Did you need to be within 50 feet of that hammer to have an accurate model and an accurate reading?
We needed to be a lot closer than we were.
Thank you.
Do you want to answer the question about the inverse square rule?
Well, the purpose of the measurement was not to measure at the property line. The purpose of the measurement was to determine, use that data to be able to determine future noise levels. So being able to measure...
Except that our bylaws are very interested in decibel readings at the property line.
Right, but the one thing too is also assuming that where the hammer was being used is typical of where it's being used, which because we can't see it, we have no way of being able to confirm that.
Did you take a measurement at the property line?
We did.
Are you going to share it with us?
Weren't planning on it, but I mean, I think, because one of the other issues is the noise levels that we were getting were basically about the same as we were getting from the background traffic, so we weren't able to get any sort of clean data. And then again, by not being able to observe the hammer operation, we had no idea if that was actually their typical operations or not.
Okay, thank you. Sorry to interrupt.
No, I encourage interruption and questions, so keep it up. Mr. Singleton, could you specifically address how the manner of operation when you're inputting data, the manner of operation of the equipment when you're inputting data can affect LEQ as opposed to LMAX?
So, yeah, so LEQ, again, we sort of call it as an average noise level, which is not quite true, but for the purposes of a public hearing, I think it's it's a good enough analogy. For something like a hammer, which we call an impulse source, which I think we're going to talk a little bit later on, but that is a source where the noise levels increase very rapidly over a very small amount of time, usually less than 1 second. That is a sort of noise level that can have a very high, quite high Lmax and sort of not as high LEQ, because an LEQ is looking at sort of the average of of that sound level over a certain time. Now, if we're talking about, multiple hammer hits, that gives you a noise level where your Lmax might be steady because each hammer hit is the same, but the peak of each hammer hit might be the same, but the actual average level for multiple impacts over the same time period creates more energy and your LEQ goes up. So if you think about, if you have 1 hit per second over 1 minute, that's 60 seconds, that's 60 hits. So you have a certain average noise level and you have 1 Lmax. Now if you hammer at double the rate and you have 2 hits per second, you have 120 hits over a 1 minute time period, you still have the same Lmax, you still have the same peak level, but your LEQ, your average noise level, goes up because you have a lot more activity happening over that same time period. So this is, as noise control professionals, we tend to want to look at LEQ to determine annoyance and impact on humans, because we found out that basically there's a greater correlation with annoyance with something like an LEQ versus just one simple maximum noise level. The analogy, or the example we always give is, what is worse? Think about something like a hammer hit pile driver. Would you rather have, 1 hit in an hour that's 100 dB, or would you rather have 10,000 hits in an hour at 99 dB? So that 1 hit, which is 100, versus 10,000 hits at 99, or if you're only looking at an Lmax, or you're saying, that 1 hit at 100 is worse than having, a 1 hit in an hour at 100 is worse than having 10,000 hits taking over that entire hour period at 99, and that's not quite true. Whereas when we look at something like an LEQ, which is an average noise level, the resulting noise is going to be very different from the LEQ versus the Lmax, and the LEQ for those 10,000 hits at 99 is going to be a lot higher than it is for that 1 hit at 100.
So, Mr. Singleton, do you know if the frequency of the hits, when RSG measured noise, was typical of how Allstone has operated the hydraulic hammer over the past several years?
Yeah, we have no way of knowing that.
If I may, I have in the existing RSG Exhibit J from our last hearing, my memory, I haven't poured through this in the last 15 seconds, but I remember me doing this basically at the last meeting, and you, sir, telling me that somewhere in this area or closer was where your initial readings were taken of the equipment.
So the record's clear, you're motioning with your hands about 3 or 4 feet?
It was within 3 feet or something like that, that you were taking readings and providing that data, if memory serves.
We were talking about sound power level and where that sound power level would be relatively equivalent to the sound pressure level, and we were talking about that would be very close.
But you were taking readings within close proximity of the machine.
But the readings that we were taking were not within 3 feet of the rock hammer, no.
Okay. What I'm basically trying to wrap my head around here is that what I need to know to make sense of this is if this gentleman was given the same opportunity to get accurate readings, or whether he was deprived getting accurate readings because he couldn't get close enough to set some sort of control to hear what the machinery was doing when it was running typically. Am I hearing you correctly?
Yes.
Thank you. So you were in your mind deprived of being able to have accurate readings even at the property line because you were not able to set a controlled reading closer proximity to the machinery itself?
Yes.
Thank you.
Let's talk about A weighting for a minute more. Is it common for acoustical engineers such as yourself and Mr. Duncan to rely upon A-weighted monitoring and A-weighted modeling to predict expected levels of annoyance from a noise source?
That is correct. We have, at this point, probably 50 years of experience that shows that we can correlate human annoyance with A-weighted sound levels.
When conducting A-weighted modeling to predict annoyance, is it also possible for acoustical engineers to make adjustments for certain types of noise?
Yeah, so I think what he's referring to is not, all A-weighted sound levels aren't the same with regards to annoyance. So a 70 decibel A-weighted sound from one source may be more or less annoying than a 70 decibel sound level from a different type of source. You might be comparing a hammer versus someone singing, for example, or a bird chirp. There is an American National Standards Organization standard that has recommended adjustments to noise levels based on the character of the source to help predict annoyance from different sources with different characteristics. And so if we know that we have this source and this source sounds like this, then you might want to add X number of dB to your prediction level to have a better sense of whether or not this sound source, this sound level will create annoyance by people.
So you mentioned the American National Standards Organization. Can you just tell us what that is?
So it's the American National Standards Institute, or ANSI. They are an organization of technical experts and engineers that creates technical standards for all sorts of areas, including noise and vibration control. And they have a number of standards for measuring sound, for specifying sound equipment, and for predicting future sound levels.
Can you explain what impulsive and highly impulsive noise consists of?
Yeah, so using the ANSI definitions, so an impulse sound, which I described earlier, it's a sound that rises rapidly in level over a very small time period. So something like a hammer hit, an explosion, a gunshot, a clap, those sort of things, where it's a very sudden sound over a very short time period. And a highly impulsive sound, the standard defines certain categories of noise sources that create those type of sounds, including things like hammering of stone and metal and wood.
And what does the ANSI recommend as an adjustment for impulsive and highly impulsive sounds?
So if you're doing a prediction of future sound levels from a source and you want to correlate those future predicted levels with annoyance, it recommends that for impulsive sound levels, when you do your mathematical equations and come up with your noise level, that you add 5 dB for impulsive sources to your results to better correlate with human annoyance, or to better predict human annoyance. And for highly impulsive sounds, it recommends you add 12 decibels to your results to, again, that sort of better correlate that future predicted level with human annoyance.
In the RSG reports that you considered, did RSG make adjustments for impulsive or highly impulsive sound?
They did not.
I would now like you to address the concept known as masking. Can you explain masking in layperson's terms?
So masking is, in terms of sound and acoustics, if you have two sounds where one sound is of the right character and very loud, such that when you play the two sounds together, you can't hear the second sound. That second sound is being masked by the first sound. So the example that I would give is that if everybody quiets down for this room right now, let's do a quick demonstration. if you listen very carefully, you can hear the fan from the projector. But if I'm talking and we're all moving and we're all shuffling in our seats and all of that, at that point, you can't really hear the sound from the fan from the projector. So in this case, it's the activity in the room is masking the sound from the projector. So basically, it's when one sound covers up the sound of a second source.
Does the use of A-weighted modeling, such as RSG performed, provide a basis for predicting whether existing highway noises will mask the noise of a hydraulic hammer?
Not really. So again, masking, it depends not only on the sound level difference between the two sources, but between the frequency balance of those two different sound levels. So you would expect that for there to be masking of two sounds, that they would both be similar in character, so that, both sounds would be low frequency bass type sounds or high frequency whistle type sounds. If you have two sounds where one sound is low frequency, maybe a diesel truck idling, and the other sound is a bird chirp, even though one sound might be very much louder than the other, the sounds are so different in characteristics that that one source won't necessarily cover up the other source. So it's the ANSI standard that we referred to earlier. It discusses that when trying to figure out if sounds mask, that you actually need to look at the frequencies of those two sounds to do an assessment to see whether or not you're actually going to have masking from those two different sounds.
Am I correct that you did not perform your own noise study of this project?
Correct.
Roughly, how much would something like that have cost my clients?
I mean, it's probably another $4,000 or $5,000, something like that.
Ms. Thorson, Mr. Kilgus, Mr. Leclerc, Mrs. Leclerc, and others have testified about how disturbing the noise of the hydraulic hammer is to them, yet RSG found that the hammer does not create noise that is more than 70 decibels A-weighted at the property line. Can everyone be telling the truth?
Yes.
And tell us why.
Because again, this gets to it's not only the loudness of sound that creates annoyance, it's the character of the sound. So something like hammering, it's a very repetitive, very impulsive type noise source, and that character of the sound can make the sound more annoying than one might predict just based on the overall noise level of that source.
If I may, please, because I'm remembering a conflict here in what I just heard. I believe I just heard you, sir, say that it never, in this report, was never higher than 70.
That was
and what I'm remembering
Yes.
from our last meeting with this gentleman was that you stopped your measurements at 70 and they could have been higher. Is that correct? That's what I'm remembering very clearly. So the number 70, when I see it on the paper here, represents where you stopped your readings, not what they necessarily were. I'm just trying to make sure, because I'm hearing two very different things.
Yeah, I wouldn't characterize it like that at all. We said whether or not the project would exceed 70 at the property line, which we said that there were circumstances in which it would. It's not a matter of stopping measurements or anything like that. It's
Right.
the model. The model.
Well, if we went back and watched the tape, I'm pretty sure I heard you say something about you alluding to in some language that 70 was the highest that you reported.
Yes, 70 is the highest that we reported in the model, but we also explicitly state that in some circumstances, that 70 decibels is exceeded at the property line. It's clearly shown in the report.
Okay, so your report shows that it could have been higher than 70 decibels.
Yes.
Okay, so what I'm saying is that you were saying it stopped at, that it was at 70. What he's saying is it could have been higher. So I think there's an important different point to make here.
Well, I think what we're referring to is that at certain properties, the existing conditions, the noise levels aren't above 70. Not necessarily at the property line of Allstone, but at other properties, It's not necessarily above 70, but it's still, residents are still being annoyed by the sound.
I just think it's an important distinction that if they stopped at 70 when it could have been higher, that you're aware of that, because what your attorney just said was very different, to my interpretation, that it didn't exceed 70.
Yeah, let me clarify, just looking at, I was going to go into this
I'm just trying
later.
to clarify so I understand.
I think it's helpful to distinguish between noise from trucks at the quarry from other noise. Because the precedents, as Mr. Carroll will tell you later, I'm sure, the precedents distinguish trucks crossing a boundary line from other noise sources, for reasons Mr. Carroll can explain to you. But the modeling that we have from RSG does predict noise from the hydraulic hammer exceeding 70 decibels at the Chandler quarry. But it doesn't show, their modeling doesn't show it exceeding 70 decibels at the other two locations.
I just noticed that all the numbers stopped at 70 when potentially it could have been higher, and I wanted to bring that up based on what I just heard from
I think
you.
that's correct. The contour lines on their maps stop at 70. You're absolutely right.
Yes.
Those are the only questions I had for Mr. Singleton.
Well, let me follow up on Scott's point, because I'm looking at Exhibit J, and we have these charts with different colored lines. And the purple magenta line is the 70 dBA line. Now,
Do we have a page number on that?
64, which is North Quarry existing hammer operations. The other charts are similar. So this is showing the 70 dBA line going beyond the property line. So take my word for it. If you were to back that up and measure it on the property line, I'm assuming that that would be higher because you're getting closer to the source.
Yes.
Okay. Thank you.
Yes, because the purple 70 dB marcation line extends across the other side of Route 103 on this map. By at least 75 feet or so from the look of it.
So I don't know if other members of the board have questions or Mr. Hall has questions.
I have no questions. I was just going to say that we have a hearing scheduled for December 11th, 12th, or potentially, and that we would respond with Mr. Duncan replying to what he heard tonight, because this is the first time we've heard this information. So rather than me stumbling through a cross-examination blind, would rather just Mr. Duncan respond to it.
All of our questions are based so we can understand what's happening, though. That's all.
That's right.
Would it be all right with council if I asked a question, just for clarification?
We have no objection.
No objection.
Mr. Singleton, I'm trying to, at least in my mind, square up what the bylaws say, which is what this board needs to deal with when they decide how to deal with the noise issues in connection with this and the permit. And it references dB. Doesn't say dBA, doesn't say the average, doesn't say the max, doesn't say any of that. It just says dB, decibels. How would you, given your expertise in this particular area, interpret this, and understanding that it's ultimately going to be up to the DRB to interpret its own ordinance, but how would you, as an expert, interpret that vis-a-vis all of these other noise ratings, the dBA and the max and the average and all of that? How would you interpret just dB?
So unfortunately, this is it's an issue we frequently come across, I'm sure RSG does too, that a lot of the local or even state level noise ordinances aren't written in a technically usable way. So, if you read that exactly as written, where dB is just decibel, it doesn't specify any sort of weighting to it. What that means is, reading it by the letter of the law, I can violate it with a dog whistle. Because I can blow a dog whistle and my sound level meter will read that sound level very nicely and nobody here will be able to hear it. So as a result, we tend to assume that when we see a municipal ordinance or language like that, when it says decibels, we tend to assume that it means dBA, because that's sort of the only rational way of being able to interpret that. But really what we do is we look at precedents, because hopefully that would inform us. If there are no precedents, then it probably really depends on your perspective and the sound source, but it'll probably, in a lot of cases, we take the worst case where we say, okay, look at an LMAX. And then that brings you an issue where if somebody on a project is standing by the property line and they sneeze, they're violating the noise ordinance. And then, like I said, it becomes usually some sort of back and forth with the zoning board, with the enforcement, to sort of come up with a reasonable way to interpret that limit in a way that works for everybody.
Thank you.
If I may, is that why you prefer LEQ to LMAX?
Yes.
Would it be helpful to people like you gentlemen if bylaws were written for weighted dB, since that's humans hearing it?
Yeah, I mean, again, we sort of assume that they have to be, because again, somebody brings in a dog whistle, it's, that will violate the ordinance.
Thank you.
Mr. Singleton is driving back to Massachusetts tonight, so thank you for letting him go first, and unless there's some objection, I'm going to tell him you're free to go home.
Want me to stay?
They go till 9 o'clock at night, so you wouldn't get home till 1 o'clock or 2 o'clock in the morning, so I think you should go.
Excuse me, did somebody
Does anybody have a question?
for Mr. Singleton? Thank you for your time.
Could you come to the microphone, please?
Just not quite clear to me when you're talking about the property line. What exactly is the property line? I mean, if someone owns 200 acres, where do you determine the property line to place your equipment for a test?
So again, that will depend on the precedence of the location that you're looking at. I think that might be more of a question for either the board or for the attorneys, but generally my interpretation of that will be the actual property line of the property if that area is in active use by the property owner. Now, if the property line happens to cross something like a wetland or someplace that it's, can't be used or is not used, then we might back off a little bit to a part of the parcel that is being in active use. But again, I can't give you that interpretation for Chester. I think that's something that's going to be more up to the town officials.
Okay, I guess the question that I have is, I guess to me, the noise assessment should take place at the actual quarry site where the hammer is located, not down on a property line where the hammer
So in this
isn't
case,
located.
Yeah, in this case, we would look at it at both the quarry's property line and we would look at it at the abutters' property lines. We'd look at it in terms of looking at compliance with the limit. We'd look at both. I would look at both.
Okay, thank you. Thank you.
Thank you. Safe travels.
Thank you for your time.
Thank you.
we could have either Mr. Kilgus or Ms. Thorson testify. I'm aware that Mr. Matoski may be sitting by his computer, ready to be cross-examined.
He's right up there.
So whatever the board would like us to do next, that we can do.
Love to go next.
Yeah?
It's up to you.
Well, I think it'd be good to have Scott and Leslie testify. And Leslie, will you operate the video and play the flash drive?
Okay, I don't need the flash drive, I need James Kilgus. Make sure everything's working. So basically,
So Leslie, why don't you need to speak into the mic and explain how you created this?
Okay, so my name is Leslie Thorson, and throughout the quarry ordeal, members of our neighborhood have recorded the sound of this hydraulic hammer that many of you in the room may not have ever heard. And so we have compiled a video, an audio-video account from various members of our neighborhood of the sights and sounds of the Allstone Quarry hydraulic hammer. Okay. So I'm going to start with this very first video here, which was taken on June 8th, 2022 in the LeClaire's backyard.
Leslie, could you step out of the way for us so we can see?
Okay, that is one of the sounds. The next one is going to be November 2nd, 2022, Cheryl LeClaire's backyard. This is actually the quarry over here, and this is the side yard where the horse turnout area is in the field. And that's quite a distance from the quarry. Okay.
Excuse me, is this Chandler Road?
No, this is the South Quarry, excuse me. These first episodes will be the South Quarry, then we will move on to the North Quarry.
Would you identify the...
Oh, yes, Clemens Road. This property is on Clemens Road, so 103 is behind this.
As you go through these, would you announce which quarry you're recording?
Yes, I will. Okay, so South Quarry. Okay, and this next one was taken on April 27th, South Quarry, Cheryl LeClaire's yard.
The people on Zoom can't hear it, so they're asking if you can put the microphone close to the speaker.
Oh, or we could turn it
About
up.
a foot in front of the speaker when you're playing your video.
Oh, okay, okay.
Against it, about a foot away.
Okay.
Do you want her to start over? Mr. Chairman, it's up to you.
Anybody on Zoom? Did you hear? I don't know if they can hear you. They can't hear me.
Zoom, do the Zoom members of our group would like us to start over?
Please hold the microphone in front of the TV speaker so Zoom can hear.
Mr. Matosky says no.
Okay, just keep going.
Okay, thank you. All right. Okay, I mean, okay. Okay, so the next one is November 22nd, 2022, Cheryl LeClaire's Pond.
I got this one here. You can just hold that from the speaker when you're playing it either way. You have to put it down. The speaker's not on the TV.
Okay, so the final, this is February 4th, 2019, in front of Cheryl's house.
South Quarry, right?
South Quarry. Okay, so the final South Quarry audio is going to be February 12th, 2019, Cheryl LeClaire's turnout area. Imagine 8 hours of that. So we're going to be moving on to the North Quarry. This was taken on April 20th, 2023 by Barry Goodrich, and we believe that it was the sound test that RSG conducted up in the North Quarry. Followed by the North Quarry, April 25th, when the sound test was over. This is from Barry Goodrich's property line. And the next one is April 25th, Barry's property. Okay, now the next one I don't have notes for, but I'm going to be able to tell what it is when I see it. So I'm going to stop it for a moment. Okay, this is a Melanson audio video.
Which quarry?
North Quarry.
You drop the other pages.
Okay, and this one is also North Quarry Melansons. No, yes, Melansons. Okay, and this one is also North Quarry Melansons. The Melansons had to move. Okay, hold on. This one is A Little Walk in the Woods by Sam Melanson.
Which quarry?
North Quarry. This is just a video of the hydraulic cameras just up in the North Quarry where they have no permit to be. That was this past June. Okay, this is the Chandler Road Quarry, and this is going to be Mike LeClaire narrating the quality of the stream.
Today is May 18, 23, time now is 9:54. This is the example of biofiltrate stream doing work just before it reaches the quarry discharge.
And this is more of that same video from Mike LeClaire, same day.
It's about maybe as much as a quarter of a mile past the quarry itself. And these are neighbors that have this clouded, polluted stream about 100 feet from their home. I hope they're not trout fishing this morning.
And then these are photos the same day, September 18th, of the Dean Brook River, which runs. This is after the quarry. You could see some of the quarry buildings here, so you can. Right, how from the discharge, but you could see the quarry in the background. Same with this one, pretty right there. White again. White again. And this one is the South Quarry sent by Mr. Hall of the equipment shed. I'm sorry, Chandler Road, thank you. The equipment shed for storage of equipment.
Not a workshop, right?
Oh, James, it has no sound.
There's no sound.
No, I think we did have sound, but.
Guess not.
step in the version that's in Exhibit II, there is audio that goes with it.
Yeah, I thought we had audio, but I guess we didn't. Oh, is it muted? Oh, sorry. Put a little bit louder. Let me just, sorry, I'm going to play that again. I had it muted. Okay, the equipment shed. Okay, this one is going to be a video sent by Mr. Hall, and it's going to be showing us the sound test at the Chandler Road Quarry. And if you could notice, the microphone from RSG is, I don't know how far you could measure that from the equipment, but this is the actual sound test sent by Mr. Hall. So again, that was the sound test for RSG on the Chandler Road Quarry. Okay, so now this, fast forward to last Tuesday. This is Paul Campbell, who came up he works for Herb. He's got a bachelor's degree in engineering. And this is where he's standing in the parking lot of the South Quarry. No equipment in sight. And this is going to be a snippet of their sound of the hydraulic hammer.
Sometimes, yeah.
So that was our opportunity to check the hydraulic hammer in the South Quarry. Okay, this one was taken from Barry Goodrich's North Quarry, 9/22/23. And the final one is going to be Sam Melanson, and it's going to be when the quarry first started operating in the North Quarry, across from their home.
This is Maria Felicity, Iron Gate. Thank you very much, Austin. I know that was very good news. I think the first place they tried it to be not being like care. So now instead of
That concludes our presentation, but we have hundreds of audio tapes like this. We have submitted them to the state, which is what helped us to get that jurisdictional opinion to tell the Yellowstone Quarry they need permits for what they're doing. And so that concludes our presentation.
They moved away, right? Something like that, small.
Yeah.
So, Leslie, are all those videos on a flash drive?
They are. The flash, we have the flash drive. And James, did you put the dates on them? And the quarries on the flash drive?
Are these identical?
Yes. Okay, so the dates and the quarries are all on this flash drive that we would like to submit.
You also have the written dates with the other sheets that are written for.
I know, I didn't bring the other sheets. Thank you, everyone. Yeah.
Jim? Jim? Other Jim, or both Jims, actually. These are the videos that you were talking about in terms of you weren't offering them for purposes of the sound?
We're not offering them to show how loud the hammer has been during these videos, because these are videos taken on an iPhone.
That's fine. If that's not being, that aspect of the videos are not being asked to be put in evidence, and I'm fine with the exhibits.
The videos have obvious other relevance other than the decibel levels, so thank you.
Frequency, et cetera,
Yes.
but not decibel levels.
Correct.
Understood by everybody?
What about when you can hear other sounds in the video?
Yeah, we're not offering anything in the videos to show decibel levels.
If I may, just to be fair, and make everything cogent here, we had a gentleman writing the volume up and down from different things, so we all know that the iPhone isn't going to be an accurate way of measuring volume. What I was trying to pay attention to were background noises, trucks, how loud the person was speaking, the volume of things compared to that. And I think it's important to remember that when you're watching videos like this, because that's going to give you a more accurate impression of where the volume from that machinery is versus the things you're hearing. Because this was very loud in this room, and we're hearing it in a way that can't possibly represent anything genuine scientifically. But the difference between voice, cars, birds, the horses, those things, that's what you have to pay attention to.
I'd like to take a 5-minute recess if we could, if all in favor. You good? Okay, we'll be in recess for 5 minutes. Where you going? Don't want to hurt the table, do you? Thank you.
Recording in progress.
It's cold here.
While still in his court, right?
You have a larger version?
I'm not mistaken. While still in Dumont's court?
Yes. Well, the board members have it already. And Mark has one. Just
Also in your
the
court.
exhibit that Mr. Kilgus is going to discuss, I have extra copies if the audience, or anybody wants copies of what Scott's going to be talking about, I have more copies here.
And maybe just for the purposes of the record, this, I think, was already admitted. We already discussed this and it was admitted, but it's understood that it's being offered for purposes other than establishing decibel levels.
Correct.
Okay. Is that clear, Mr. Hall?
Yes.
Okay.
This is, excuse me, is Exhibit 22, is that what we're discussing here?
Yes, that's correct.
Okay.
And Scott has actually a larger copy that, when he's done, maybe we will leave with the board because it's a little more legible. So why don't we get started? Scott, why don't you state your name and address, and we'll get started with that.
Scott Kilgus. I live at 296 Blackberry Hill Road in Gassets.
And you've already submitted an affidavit, correct?
Yes.
And there were some calculations in the affidavit?
Yes.
And what you've prepared, what we've marked as Exhibit 22, is this to modify the calculations in your affidavit and to explain how you did it?
Yes, it is.
Okay, so why don't you walk us... Go ahead.
Excuse me. Could we have a little background on the witness?
Yes, it's in his affidavit, but we'll repeat it.
Okay.
Scott, why don't you identify, explain your education?
So I hold a master's degree in architecture as a graduate degree. I also have an undergraduate degree in geography, where I studied mapping, and I specialized in interpretation of aerial photography for land use planning purposes, and actually performed that type of work for Albany County in New York, doing mapping for their land use programs.
And tell us a little bit briefly what you do for work.
I currently am working with Gassets Group. I actually have lived in Gassets for just about 50 years now. Many, many years ago, I, with a couple friends, started the construction company, Gassets Group. That business started in what is currently my home, in 2 bedrooms of what is now my current house, before it moved to the lower level of my house and eventually moved to Ludlow as our home office, and for many years have employed many local people who have worked for Gassets Group for many years.
So why don't you walk us through how you've calculated the amount of rock and other materials that are likely to be excavated in order for the plans that Allstone has submitted to come to fruition, in the sense that the building, the 20,000 square foot building, will be usable. How much will they need to excavate so that the 20,000 square foot building is usable?
So when I was looking at trying to figure out Mr. Matoski's calculations here,
for how much material would need to be removed. I guess what they are presenting here is, the best that I could figure is how much material would have to be removed to just put the building in at the site. They're not saying how much material is going to be removed from the site altogether. They're giving you a number of how much material would have to be removed from the site in order to place the building in there. So if you look at their sheet there where he's got the red cross hatching, basically, and you look at his numbers down below, what he's giving there is the footprint of the building plus, maybe a little, maybe 50 feet each direction all the way around the building, like they were going to, dig a vertical pit 35 feet deep and then drop the building down in there, and apparently that's what they're saying they plan to do. It doesn't seem to me that that's what you would be able to do to make that building operational. If you look at the cross-section that I drew where it shows the blue color there on the cross-section map, they're showing where the building would be down at the bottom there. You can see at the back of the quarry where the little red cross-hatching goes, it just barely past where they are showing that the building would be. And then just past that would be a near vertical 100-foot tall wall of stone that they say that apparently they propose that they're going to remove later after the building is in place. So it doesn't seem like that would really be a possible thing to do. They also do not include in their estimate of material that they propose to remove in the first 18 months the area that would be required to lower the road to get into the site, the area to lower that would be required for the settling ponds and the stormwater runoff ponds, or for any area for trucks to drive around, maneuver around the ponds and the site and the building. If you look at the topo map, where I have labeled the different areas A, B, C, and D.
Can you hold that up so everybody knows which one you're looking for? So it's the second page.
Yeah, looking at, which is the aerial topo map. Area A is the area that Matoski's estimate of material to be removed in the first 18 months would encompass that area. That just doesn't seem like it would enable them to operate anything at that point, so I don't see, there's really no use in just clearing that one little spot and dropping the building down in there. The road hasn't been dropped down to it. Where I show area B, that's that vertical wall that would be behind the building. I don't see how you could build the building and then later remove that material behind it. You'd obviously have to remove a lot of that material before you built the building, or you wouldn't be able to remove it. The area that I have labeled C is the holding ponds and the stormwater runoff ponds. That area would all have to be lowered before you could make the building usable, because, it's all part of the process of using the building for stone cutting. The area that I have labeled D, I'm saying a lot of that material would also have to be removed because it's also a steep hill right behind where the ponds and the building would be, and you would not be able to remove that later on without it coming down and, disturbing their operational area. So it just seems to me that what they're saying, they need to remove Mr. Matoski's original estimate that he shows on the cross-section page. He shows that he comes up with 155,000 cubic yards that they'd have to remove. I can look at the same cross-section area that he shows there, the red hatched area. And, yeah, you know, he's obviously looking to minimize that number as much as possible. I can take his same graph there and look at, you know, the areas on it, and I can easily make that come up to 175,000 cubic yards of material that he would be removing there. If you remove the other areas that I'm suggesting would need to be removed to really make this quarry operational, the B, C, and D areas, you're going to have to remove closer to 300,000 or 400,000 cubic yards of material out of there. So their proposal is that, you know, this is what they're going to do in 18 months. And I think part of the reason that they propose such a low number is because in 18 months, that works out to be just about 40 truck trips a day that they would be doing in and out of the quarry. But I think that's a very misleading figure. I think that in order to really make the quarry operational and all this other material was removed, that it would really be closer to 80 truck trips a day, at least during that whole period when they were preparing to get preparing the site for the building. The other thing I think that's important to keep in mind here is that they're proposing to do this, you know, over an 18-month period. Of course, there's always the issue of, you know, what happens if 18 months later they have half the material, you know, that they've projected removed. Are they going to stop at that point? Or what happens at that point? Who knows? Also, that whole time that they're removing all that material has to be trucked to Chandler for processing, because they have nowhere to process it here at the South Quarry at this point. So they're going to be removing all this material, plus material, they're leveling the North Quarry, which is, I can't remember, another 50,000 cubic yards of material or something like that, trucking all of this down to the Chandler Road Quarry for processing. That's just a huge amount of truck traffic. It's way beyond what the current permit allows at the South Quarry, which is, you know, 80 truckloads a day. And I just wanted to make it clear that I think that what they're proposing here is rather misleading.
Thank you. Any questions? Thank you.
So I think this exhibit was not ruled upon yet, so now I'm offering it again. And Scott, do you want to give me the larger version so that they have that?
We have no objection to it being entered.
Here's a larger version.
I think we did. Yes. Okay. All right. I'll take a motion to accept exhibit number 22, Scott Kilgus markup of TCE plans for the South Quarry. Moved by Harry, second by Gary. Any further discussion regarding Scott Kilgus markup of TCE plans for South Quarry? Yes, sir.
Rainey Melanson. I just wanted to add to what Leslie said about listening to that for 8 hours a day. It was 10 hours a day, no break for lunch. Starts at 7:01 every morning, goes till 5 o'clock. Thank you.
All in favor?
Aye.
Exhibit 22 is accepted. All right. Okay. And Steve?
I have some questions for...
Excuse me, Jim, you're still up.
Thank you. I have questions for Mr. Matosky at this point.
Sure.
Mr. Matosky, how are you today?
I'm doing great, Jim.
I take it you're on a golf vacation?
That is not correct.
No?
but
Okay.
thank
Are you someplace warm?
I am in Phoenix, Arizona.
I hope it's fun. I'd like to start by asking if you know when use of the hydraulic hammer at the South Quarry commenced.
I have no idea.
If one of the Julians were present, would one of the Julians be able to answer that question?
I have to ask them, Jim.
Have you read Ms. Thorson's affidavit in which she says when she first heard the noise of the hydraulic hammer?
Yes, I read through all the affidavits.
Do you recall she said it was several years ago?
Okay, I believe you.
So 2018 or 2019, does that make sense to you?
That's her affidavit, Jim.
Have you considered what ordinances or what version of the Chester zoning ordinance was in effect in 2018 or 2019?
I haven't specifically looked at that. We got involved with this project a little over a year ago, and we applied for permits earlier this year, and typically we would look at the zoning that's in place at the time of the application.
Well, in evidence is the 2017 ordinance at page 68, section 4.9 reads, I believe with the same language as the current version, it says, noise levels or frequencies which are not customary in the district or neighborhood or which represent a repeated disturbance to others shall not be permitted. So do you know, was noise of a hydraulic hammer customary in this district or neighborhood? In other words, I'm sorry, I'll start over. Was noise of a hydraulic hammer customary in this district or the neighborhood of the South Quarry before Julian started using a hydraulic hammer in 2018 or 2019?
I don't know when they started using a hammer, and I'm not the noise expert in this case, Jim.
Right, but I'm asking you, since the Julians aren't here, you're the only one I can ask this question, was the noise of a hydraulic hammer customary in this district or in the South Quarry neighborhood before the Julians started using a hydraulic hammer? Do you know the answer to that?
I do not. I don't have any. I've never been to Gassets until about a year ago.
So do you think the Julians would be able to answer that question?
I have no idea.
A related question, under the ordinance that was in effect in 2017, was there any loud noise that had a loudness or frequency of occurrence that was similar to the noise, the loudness or the frequency of occurrence of a hydraulic hammer that was customary in the South Quarry neighborhood in 2018 or 2019 before the Julians started using their hydraulic hammer? Do you know?
Same answer. I did not visit Gassets out of my vehicle until about a year ago.
And lastly, about the South Quarry, do you know whether there was any loud noise that repeatedly disturbed people in the South Quarry neighborhood before the Julians introduced the hydraulic hammer in 2018 or 2019?
Again, same answer. I don't have any information to support or deny or offer any kind of opinion about anything prior to my involvement with this project.
But the Julians were present in Chester at that time, correct?
Based on the documentation that I've looked at, they were involved, yes.
So if they chose to testify, they could answer those questions, correct?
I don't know.
I have the same three questions about the North Quarry neighborhood. Would your answers be the same for the North Quarry neighborhood?
Right. My experience on this project and in this neighborhood related to any activities other than perhaps once or twice in my life driving through it. But, serious getting out of my vehicle and listening and experiencing the neighborhood all began about a year ago.
And I have the same 3 questions about using the hydraulic hammer at the Chandler Road Quarry neighborhood. Would your answers be the same?
Correct. And same, all 3 sites I visited when I first got involved with this project.
Let me ask you, have you read the RSG report that is Exhibit J as in John?
Yes.
So are you aware that at page 70, figure 35, which is PDF page 75 if you're looking for the PDF page, but it's page number 70, figure 35, RSG reports that there will be more than 70 decibels A-weighted at the property line when the Julians are using the hydraulic hammer? Are you aware of that?
I did read the report, looked at those exhibits, yes.
Do you know before the Julians started using a hydraulic hammer at the Chandler Road Quarry, were they exceeding 70 decibels at the property line?
I don't know, Jim. These seem like they should be questions for Eddie, who just left the room.
Well, I really want to know is, if the Julians were present, could they answer these questions? And your answer is you don't know, or you think they could?
Poor dies.
My questioning wasn't that difficult. I hope he didn't pass out.
I'm listening.
Okay, so I'm now going to turn to Exhibit P4, which is the collection of Chandler Road Quarry permits.
Okay.
PDF page 3 of Exhibit P4 has a box at the bottom. Does it state that, quote, the quarry is allowed non-conforming use?
Which page are we talking about?
PDF page 3 of Exhibit P4.
What was the question? Because this is the application for zoning permit, is that the one you're looking at?
Yes, it is. You see there's a box in the bottom quarter of the page?
Yep.
Does it state clearly that, quote, quarry is allowed non-conforming use? Did you hear that question, Mr. Matowski?
I'm sorry, yes, my answer was that's what it says as I read it.
Well, thank you. I guess we just didn't hear you. Have you seen, you were here this evening, you saw the video that Ms. Thorson played that we obtained from Mr. Hall that showed the cutting operation inside the building? Did you see that?
I did, yes.
And I believe when you were present at the very first hearing, Mr. Marks testified that there are 20 employees working inside what has been permitted as a storage shed. Have you been inside the building that was permitted as a storage shed?
Yes, I walked through that building.
How many employees did you observe operating the cutting machines inside the storage shed?
2 or 3, maybe more.
Tell us what they were doing.
Cutting stone, So there, as we saw and I described at the site visit, there's multiple buildings on the site, and the stone starts at the quarry end of the property and works its way to the pallets on the south side of the quarry. And each step of the way, the material is reduced in size, first with blasting, second with the hydraulic hammer, third with guillotines that are hydraulic press operated, and fourth with a wet saw. And I've also observed them manually making rocks smaller with hand tools. So all of those activities I've observed at the property.
Thank you. I now would like to turn to Exhibit A as an apple from the town's website, which is the application in this case. Let us know when you found it.
Yeah.
I'm going to read part of it. In the middle of the page, it says, description of request. And I'm now going to read it. Quote, modifications to three-dimensional stone quarries, including the relocation/consolidation of processing operations, comma, implementation of stormwater improvements at the Chandler Road Quarry, comma, the construction of new building for processing at the South Quarry, comma, and a new contractor yard at the North Quarry, period. See the project narrative for more information. Did I read that correctly?
Yes.
Am I correct that the application does not apply for a zoning permit to use the storage shed to cut stone?
And here is that the activities that you're describing and that I just described, the Chandler Road facility, will be relocated to a new building at the South Quarry, which was the testimony I gave during my presentation to the board.
Yes, I understand that. As I reviewed the minutes of that meeting, you were quoted as saying that the application that's now in front of you, Exhibit A, included an application for permission to use a storage shed on Chandler Road to cut stone. That's why I'm bringing it up now, because it's right in front of you and it doesn't seek that permission, does it?
In its entirety, but regardless, the relocation of Chandler Road includes all of those activities that are described that are occurring other than extraction. So the mechanical guillotines and the saw operations are proposed to be relocated from Chandler Road to South Quarry, and we're seeking, as I said at the first hearing, about 18 months of time to make that change happen.
I know you said that at the first hearing, but the application that's initiated this proceeding, which the public was noticed, does not seek permission to operate the storage shed to cut stone, correct?
I disagree with that statement.
Okay, well, show me where it does. Tell us where it does.
The relocation process.
Excuse me, Jeremy, you're breaking up?
I'm saying the relocation of operations from Chandler Road is inherent in the sentences in the description for request, and I believe it's more carefully articulated in the narrative, which should look at that as well.
So why don't you turn to the narrative, which is your Exhibit D.
Excuse me, I have a quick question, if I may.
Please.
Just so I can understand what's going on. we're taking testimony, and this is a legal quasi-judicial proceeding. I would love to know who Mr. Murtowski is consulting with off camera. I'm just curious, because I think that affects our meeting.
I'm in an empty room with no other human beings, and I'm looking at my iPad to read these
Okay, it
exhibits.
appeared that you were speaking to someone.
I think his microphone keeps cutting out.
Okay, I was just curious, that's
You
all.
might want to tell him to face forward, because that's the only way that his microphone is working when he's facing the computer. That's what I've noticed. So if you could tell him that, that might help.
The suggestion's been made, Jeremy, that you're more, that we hear you better if you're when you're facing the computer.
Yeah, sorry about that. I know my headset is not, mic on my headset's not working today, so it's using the laptop microphone, which I have to be speaking at the screen for it to pick it up well.
So do you have Exhibit D, which is the narrative that you prepared?
I do.
And Exhibit D, you wrote it, correct?
No, I reviewed it. It was written by Colin Johnson.
Oh, we can't hear you. You're not looking at the machine.
I reviewed and approved it. It was written by Colin Johnson, one of my engineers.
And you signed it?
No, Colin Johnson signed it.
Okay. So your firm prepared it?
Correct.
Okay. And I'm going to read to you what it says about the Chandler Road Quarry on page 1. Chandler Road Quarry. A, eliminate stone splitting, cutting, and processing operations from this site, relocating these operations to the South Quarry, period. Quarrying of stone will continue at the site, and blasted stone materials hauled in trucks periodically to South Quarry for processing. B, install best management practices, BMPs, to ensure water quality requirements are met for discharge from the site in accordance with a multi-sector general permit, permit pending, and Did I read that correctly?
Yes.
Do you see anywhere in Exhibit D an application to this board for permission to operate the storage shed as a cutting facility?
I'm sorry, I don't understand. The sentence that is articulated in bullet point A, to me, seeks approval to continue operations of the cutting that we saw at the site visit until such time as a new facility can be constructed to do that on the South Quarry. That's what we're applying for.
And you understand that the cutting is not presently permitted under zoning law, correct?
And that's a legal decision that someone else should make.
Now I'd like to look at what we marked as Exhibit 7, but Mr. Bristow has renumbered as, it's all part of II, I guess. Yes. So I have specific questions about the response to subpoena questions 4 and 5, and I've made copies of that for the board because the copier was crashing with all the color pages. We had to make these in black and white for you. For this really to work, when you're looking at this, you should look at the digital copy because it's in color. Mr. Murtowski, if you could have the responses to questions 4 and 5 in front of you. Let's see here.
Hello? Can you hear me?
Yes, do you have that in front of you?
It's trying to load on my laptop, or on my iPad. It's a huge document. But maybe you could, I'm pretty familiar with the testimony, so if there's something specific, and I can wait till it loads here.
So if you're pretty familiar with it, maybe you don't need to have it in front of you. On PDF pages 48 and 49, there is a very large white cylinder on the outside of a building. What is that?
Do you have the page number, Jim?
Well, it's not, the pages are not numbered, so you have to use the PDF. And it's PDF pages 48 and 49. I'm holding up my color copy, which is a large white cylinder. It almost looks like a silo, but it's not as tall as a silo. You know, that would have silage in it, but it's not that tall. And it's white and has a white pipe entering from the top. And in this picture, there's a red ladder lying at the foot of it.
I guess my page numbers are different than yours. My page 48 is of a wheel loader cut sheet.
Well, if you're familiar with a large white object that looks sort of like half of a silo on the outside of a building at the Chandler Road site?
I'm not familiar with whatever it is you're looking at. I guess I need to look at the pictures. I'll try to sift through this thing. So which question in the subpoenas was it, 4 and 5?
Yes.
So it's below 4 and 5. The PDF document, which is the MSGP.
It's right after your...
multi-sector permit stuff?
Yes, it's right after the exhibit, or plan C4-301, which is the Chandler Road SWPPP plan.
Yep.
It's right after.
Getting there. Hi.
You find it?
God, I'm in a meeting. Sorry. Trying, Jim. So many pages in here. Okay, now I'm getting there. Oh. I see the tank you're talking about. I guess I didn't specifically look at that. What's the question? What is it?
First, what is it?
It appears to just be a water holding tank. My guess is that it is affiliated with the wet sawing operations. But
If the Julians were here, if the Julians were present, could they answer this question?
yeah, this was not my document that I provided. This was their document that they provided. So
They are meaning the Julians prepared this?
I believe so. This is not my picture.
When was this object installed? Do you know when this was installed on the site?
I do not.
I'm sorry, I didn't hear you.
I do not know when that was installed.
Do you know, is there a zoning permit or an amendment to a zoning permit for this large white object, whatever it is?
I do not know that. But again, it's not, it wasn't a document that I produced.
In your understanding that this application seeks to continue cutting in the storage shed, according to your understanding, are you seeking permission to continue to use whatever this is, this large white object?
It's a water tank. It looks like a water tank. So if that is associated with the cutting operation, which I can assume that it is, then yes, that would be relocated as part of the operations.
If it's a water tank, can you explain the large gray object to the left of it that it's connected to? What is that?
It appears to be some sort of a metal hopper, potentially to segregate fines from the water as it's being circulated through the pumps. It's a closed, my understanding of their operation there is it's a closed loop system that recycles the cutting water, and my guess is these are components that would filter that water as it's being recirculated.
And the water that they use, do they take it from the brook, Dean Brook?
Yes, to address any kinds of evaporation, the system is filled with water from the brook.
So part of this operation withdraws water from Dean Brook, correct?
Occasionally, yes, but at very, very small volumes.
Yeah. Is that approved of in any zoning permit that you're aware of?
I'm not aware that a zoning permit would be required for such a thing.
Well, if someone had applied for a zoning permit to use cutting devices, that would have been included, would it not have been? Are you answering? You're nodding your head. That doesn't do much.
The answer was I don't know.
Okay, thank you. On PDF page 74, there is depicted a long, wide bed of rocks with a pipe lying in the middle of it. Do you know what that is?
Yes.
What is that?
That is the discharge swale that we saw at the site visit that was installed as a best management practice to address water quality from the quarry.
Was that installed under your supervision?
Yes.
Is there a zoning permit for that?
No.
Why not?
I don't believe one was required.
Is it an alteration of any kind of an existing use?
It's certainly an alteration. It was designed to address stormwater quality from the site that was substandard, so there was a new practice installed to correct that.
On PDF, the same exhibit, PDF pages 50, 51, 69, 70, and 71, there are rectangular pools or ponds. Do you recall those?
Yes, those are the recycle. That's a additional part of that cutting recirculation system, the closed loop system.
When were those rectangular ponds created?
I do not know.
Who created them?
I would assume the Julians created them, but I don't have any proof of when they were installed. Again, they were there when I got involved in this project about a year ago.
Do you know how deep they are?
I can't say that I've measured them specifically to know.
So you don't know when, I think you said you don't know when those were created, correct?
Correct. And I don't know how deep they are.
If the Julians were present, could they answer that?
Probably.
Did the Julians obtain a zoning permit for these excavations?
I have not seen one.
In the same exhibit at PDF, pages 72 and 77, milky water in a brook is shown. Do you know when those photographs were taken?
Not specifically. I have seen pictures of and I've observed that condition.
You were present this evening when a video was shown of milky white matter entering the brook in September of this year after you testified before the DRB. Do you recall seeing that today?
Yes.
So the discharges are continuing as we speak?
There have been discharges that occurred that were separate from the discharge. There's three on the stormwater pollution prevention plan that we submitted to the state of Vermont. There are three distinct discharge points that we identified. The big swale with the white pipe in it is related to, if my memory serves me correct, the third of the three. The other two are on the south side of the property, and that's where I believe those additional discharges that we've seen in heavy rain events have been occurring.
And are they entering the brook by means of a swale?
No.
By means of a pipe?
No.
Have you reviewed the materials that were produced by Mr. Hall in response to the board's order?
Maybe not all of it. I got a large data file while I was in travel yesterday, so I haven't had a chance to look through all of that. But a lot of the materials he and I have collaborated on.
So, do you know whether or not what Mr. Hall produced is a complete collection of documents that your office submitted to A&R for a stormwater permit, as was ordered?
I would assume so. I can't.
Well, let me represent to you that there's nothing that Mr. Hall produced that that includes or refers to the state's rejection of your request that this just be treated as an MSGP. Do you know what I'm referring to?
Yes, I've had several emails and correspondence, and I've met with folks from the Agency of Natural Resources related to the multi-sector general permit that we applied for back in March.
And in which you testified about when you were here before, correct?
I think so.
Yeah. And the materials we received from Mr. Hall don't disclose that the state said no to you in one respect, correct?
I don't think there's been any official decision from the state of Vermont. We're still waiting for a more official determination as to whether or not we need a multi-sector or not, or some other permit or not, or multiple permits. That's what we're trying to.
Didn't the A&R distinctly inform you that an MSGP would not suffice? You must obtain a separate permit from the wastewater division?
There was an email to that effect. It wasn't a final decision, and I met with Agency of Natural Resource personnel and have asked for them to clarify their position on this. So I don't have that final decision yet.
Right, and that wasn't produced, was it? Or do you know?
I don't know if that was produced or not.
So regardless of whether it was produced, you know to a certainty that as things stand right now, the state has said that an MSGP will not suffice, correct?
I don't think that's that's not their language.
What was their language?
There was a question as to whether or not an industrial direct discharge permit under the wastewater management division would be required, and that may or may not be in addition to or in lieu of a multi-sector general permit for this site. And that's the decision that we're still waiting for them to make.
And didn't they tell you that they're not going to make it until you propose a specific flocculant, F-L-O-C-C-U-L-E-N-T?
No.
So what, are they waiting for any information from you?
No.
So you're just waiting for their final decision whether you have to obtain an individual discharge permit? Is that your understanding?
It's an industrial direct discharge permit from the wastewater management division. It's not an individual permit.
It's an industrial,
yes.
industrial discharge permit.
Correct.
Thank you. That's all I have.
Thank you, Jeremy.
Am I free to go?
No.
Mark?
I've got a few questions. Good afternoon. Afternoon still in Phoenix?
It is, yes, it's 5:30 Phoenix time.
Happy hour. So just a few questions for you. You mentioned Mr. Colin is it Johnson?
Correct. Colin Johnson is an engineer that works for me.
He works for you?
Correct.
And he actually signed the May 31st, 2023 application, or at least the summary of the project?
Correct.
You're nodding yes, so I take that correct. Where did,
Yes, sorry. Yes, he signed it, I reviewed and approved it.
where did Colin Johnson get the information that he reported to in this permit application? Where did he get the information from?
We compiled it from a variety of sources, including conversations that we had with the Julians and site visits, surveys that we compiled, and we prepared the application. He did that mostly, and then I reviewed and approved it before it went out.
So I don't want to be repetitive. It's kind of late in the evening. I just want to hit a couple of high notes that Brother Dumont has covered mostly. In the application and in the summary, it talks about the Chandler Road property. Is that stone is being moved there for processing at this time. Do you know when stone first began being moved from off-site onto the Chandler Road property for processing?
I do not know when that started.
Did anyone tell you, speak about when historically stone first was being brought from off-site onto the Chandler Road property for processing?
I have a vague understanding of the history that occurred prior to our involvement, where there were different owners of the facility and different operators over time, and then the Julians became involved, I believe, for the Chandler Road site, first as maybe a operator with a lease, and then eventually purchasing the property. But again, I don't have direct knowledge of when certain equipment or when certain activities started.
Well, there are statements in this summary talking about the Chandler Road property that it's a pre-existing use, so it doesn't need conditional use approval. Is that correct?
Correct. But
who rendered that opinion to you?
I reviewed several documents from the town, including the one that Mr. Dumont crossed on me a little while ago, and there were multiple instances where various zoning administrators had written down that there was a non-conforming pre-existing quarry at this site, and so those are the type of language that we repeated in our zoning application for this activity.
So let me ask you about that. You took that information and you worked with Mr. Johnson and you put it in a summary of this report that there was a pre-existing non-conforming use of this site as a quarry, and you interpreted that to mean that we can truck in stone from all over the world and process it at the Chandler Road quarry. Is that right?
No, that's not.
Isn't a pre-existing use of the property as a quarry limited to using it as a quarry and not as a manufacturing facility?
Again, I think that would be someone else's decision to make.
Well,
a zoning administrator or a court. But in terms of what this document says and what we applied for, it was to cover any activities that may not have been permitted previously, and to allow those activities to occur for a limited period of time until they could be relocated, and so that those activities could be permitted if they were not previously, to continue to operate.
So is there any question in your mind that stone from off-site has been brought into the Chandler Road facility for processing during the whole
We've
time?
testified that that's what's happening today. I don't know when that activity began, but we've seen that activity during this hearing and prior to that.
Did you see one shred of evidence anywhere that stone from off-site was being brought onto the Chandler Road facility for processing before Chester had zoning regulations?
No.
Do you know when Chester?
That would be when I was about 5 years old.
Yeah, okay, well, let's see, what age would that be? So that would be about 1970?
Yeah, I think I read it was 75 that they adopted, so, but I could be wrong.
Do you have your birth? No, never mind. We went through that the last election, so. Let's talk about, you testified that stone from the North Quarry, that if it couldn't be palletized there, that's what was that has been transferred to the Chandler Road site for cutting?
Correct. There's been stone from the North Quarry and the South Quarry brought to Chandler Road to produce the products that they produce.
Do you know where, do you have any information on where the previous owner of the North Quarry was processing his stone?
I don't have any of that information.
So how about Mr. Johnson? Do you think he had that information?
No, Mr. Johnson doesn't have anything, doesn't have any knowledge that I don't have.
Okay, so then let's talk about this summary, and it talks about the timeline. And this summary says about the timeline for the project on page 6 of 7. This is the May 31st letter. That during construction of the new processing building at the South Quarry, the applicant is requesting temporary use approval to allow continued processing activities to occur at the Chandler Road Quarry. Until such time the South Quarry is complete and relocation of operation can occur, it is anticipated the construction phase will take more than a year, and an 18-month temporary continued processing use is requested of the Chandler Road Quarry. Who made that estimate of 18 months for completing the construction at the South Quarry and the excavation at the North Quarry?
I did.
You made that estimate?
Yes.
And all this stone that we've been talking about removing from the South Quarry to build this 30,000 square foot building, and the North Quarry to make it a construction yard can be done in 18 months. Is that what your testimony is?
That is my testimony. It's to correct you, it's a 20,000 square foot building, not a 30. And we have requested an 18-month period to do so. I was asked by the board last time to produce some volume calculations. So, and I think that was part of the request of Mr. Dumont as well. So I did some preliminary calculations about that. I can speak to those if you wish.
Would you tell us what volume stone you believe is necessary to remove from the South Quarry to construct the building with all the trimmings, meaning access around it, getting the road down to the level so you can actually use the building? Do you have that with you?
Yep. I do. I had estimated that about 155,000 yards of material would have to be excavated to construct that building, which was the question. It wasn't how much of the quarry had to be built to do that. So I estimated about 155,000 cubic yards of that. And of that, roughly half of it could be stored on site in a berm that would also serve as a sound barrier for future activities until it could be processed. And the other half of it would need to be processed and removed. I disagree with Mr. Kilgus's testimony that it would be trucked to Chandler. I don't believe that that would be the case, since that would be more of a construction project and not a aggregate or a dimensional stone activity. So more than likely it would be crushed and processed as aggregate, and they have a permit to do that. So that's what I would expect. The majority of that material would be processed in a crusher and hauled away, about half of it, and the other half of it stored on site in a barn.
Is there any reason why you can't store all of the excavation from the South Quarry at the South Quarry for later processing once the building is constructed?
It would be you could do that. It would be a much larger berm. Like I said, I think, and means and methods of how they accomplish that is not my directive, but from my knowledge of construction and looking at the volumes here, I think it would be reasonable that, again, they store about half of it and they would haul about half of it. And again, not to Chandler Road for making palletized thin stone, but aggregate or fill for other projects
And the
somewhere
same
else.
question for the North Quarry. What is your calculation of how many cubic yards are intended to be removed to make that a contractor's yard and not continue on with extraction?
That was about 25,000, potentially as much as 30,000 cubic yards of material. And in that site, there's not as much opportunity to burn. So the majority of that would have to be hauled away.
Any reason that could not be removed to the South Quarry rather than to Chandler Road for processing in the storage barn?
Again, depending on what the type of material is, whether it's, so when we look at a site like that, we know that a portion of it is overburden and a portion of it is rock that may not be suitable for their pallet stone. So it could be hauled to the South Quarry and crushed if it was aggregate, and if it's just fill and overburden, then it wouldn't be hauled. None of, other than the type of volumes that are currently being processed at Chandler, I don't envision that there would be a significant increase in production from either of these construction activities. It would be the goal to get the project completed to the grades, and to the extent materials could be stored on site, they would. But there's no testimony, and it's certainly not my intention to tell the board here that we're hauling hundreds of thousands of yards of material to Chandler Road. That's not what's being proposed.
Is there any reason that any extraction at the North Quarry could be halted until the South Quarry building is constructed during this process?
If that was a condition of approval, and they wanted to be sequenced, but that would not be what we proposed. We proposed to try to get the noise and activities completed as quickly as possible, and we estimated that quickly as possible would be 18 months.
Well, isn't devoting all of your resources to finishing the South Quarry excavation, isn't that the quickly as possible, the most quickly as possible project?
That would have to occur, and at the same time, I know that there's an interest in completing the change of use from quarrying to something else at the north site, so those activities, I think, would occur at the same time.
I don't have any more questions, thank you.
I have a question, if I may follow up, just to clarify.
You may. Mr. Hall, are you going to have any follow-up at this point?
No.
Okay. So, sure.
Thank you. Mr. Murtowski, you just said you believe that there's already a permit to allow crushing and creation of aggregate at the South Quarry?
Yes.
I have the 2003 conditional use permit in front of me, and it says it's for dimension stone. Are you thinking of some other permit?
There's an Act 250 permit for crushing. I have to go back and look and see if the zoning.
But the zoning permit is the exhibit that's on the board's website, and it specifically says it's for dimension stone, and it doesn't mention any use of a proposed crusher. So do you want to modify your testimony and say there's an Act 250 permit for crushing, but not a zoning permit?
I know there's an Act 250 permit. I don't know for sure the whether or not there was ever testimony or
Could you?
anything related to
Let's
crushing
favor-
for the zoning.
If you think there's a permit out there issued by the Chester Development Review Board that authorized not dimension stone, but aggregate and use of a crusher at South Quarry, could you please get that to Mr. Hall so he can share it with us quickly?
Absolutely.
Thank you.
I'd like to recess this hearing. Do we have another date to continue it?
December 11th.
We're going to recess until December 11th at 6 o'clock?
Everyone seems to have agreed on December 11th.
Okay.
Yep.
I'll take a motion to accept December 11th. Moved by Harry. Second by Gary. All in favor?
All right.
Recessing to December 11th.
Thank you.
Have a nice Thanksgiving.
Thank you.